somebody asks us to delete their data. Can they do that? What do we do?
Yes, it's an interesting and complex question to answer. And before we jump into this topic, I'd like to remind the listener that Ken and myself are counsellors, not lawyers. I, as data controller for Counselling Tutor, have looked at the question and I'm answering it in this way. So, of course, the client can ask you to delete the data. They can ask you for anything. It's whether you comply with that and what defence you can put up to say you can't delete it. Now, to look at this in a bit more depth, we're talking about UK General Data Protection Regulations. But if you're listening in another part of the world, almost certainly you'll be governed by some form of data protection legislation. If you are listening outside the UK, might be worth you looking at whoever is the regulator for data in your geographical area and asking the question. So under Article 17 of UK GDPR, the legislation that came in 2018, you can keep personal data under certain conditions. So personal data would be things like phone numbers, contact details, client notes, referral letters, any financial transactions. And under GDPR, there's something called the right to erasure, or sometimes it's called the right to be forgotten. Now, a client can request you delete data if it's no longer needed for the purpose it was collected. So when does this right of erasure apply? When can someone actually say to you, I want you to erase the data if it's no longer needed for the purpose it was collected? So say, for instance, a potential client rings you up, leaves information and says they're interested in working with you, and you don't go ahead for whatever reason that is. You still have their phone number, and good practice if you're not working with a client would be to delete that anyway, because you've got no reason to have the information. But if they said, I want you to delete it, you could delete it, or they withdraw their consent. So again, they might phone up and say, you have my phone number, can you delete it? Now, we come to the area where a counsellor can decline to delete data. So things like, if the data is needed for a legal obligation, things like tax, almost certainly your bank will have the client's details. Now, you need that for tax purposes, because if the tax people say, where are you getting your money from? If they want to look at your bank accounts, if you've deleted that data, they may say, look, you have to prove where your money's come from. And also, we are asked to take client notes. If a client makes a complaint, one of the things that professional bodies will ask for is notes. Or if a client takes their abuser to court and they ask for their notes, then we have to supply them. So the answer to the question is that we can, in some cases, decline clients' requests to delete their information. And I would say at this point, it's really useful to have all this in a contract. Right from the very beginning you contract with the clients, it's always best to have a policy that they can see of why and how you keep data, so they understand that. And at that point, they may say, that's fine, that's okay. Or they may say, I don't want you to have my information. I'm not willing to give it you. So therapy shouldn't take place. And it would be good just to reinforce the point of the importance of contracts.
Yes, definitely. This is a tricky subject because we're speaking about legislation. So we're talking about the law. And when we're speaking about the law, we may not be fully read in on all the moving parts of that. So listening to this, I would not recommend that you take this information and implement it. If you find yourself in a situation where a client is saying, I want you to delete my data, and you hold a certain amount of data on that client, I would suggest that you contact the Information Commissioner's Office, the ICO. If you are in the United Kingdom and you're collecting a client's data, you're going to have to register with the ICO in the first place anyway. And part of their service is to offer you support. So one of the things is, if somebody asks you to delete their data, you do have a grace period. You do have a time frame to do that in, which allows you to think about it, to note down what you've been asked, and then to get the right recommendation and guidance on that. And I would be going to the ICO rather than your ethical body. The ethical body is taking care of you as a counselor and your ethical practice. The ICO is taking care of you as a person that holds data that people share with you. So that's just underlining, Rory, your disclaimer at the beginning that we're not the experts on this. Now, if we look to our ethical body, and I'm going to use a UK ethical body as an example, where they may suggest that you would keep a client's data and the notes associated to that client for 6 years after the therapeutic relationship ends. And that's for adults. If they are children, then up until that person is 25 years old. So you can be holding that data for a significant amount of time. So that there is the ethical body stance on it. However, if there is a request to remove that data, then we need to think differently. Now, this is where it becomes tricky, because I'm going to use an example here, and this is just 100% hypothetical. Let's say we've worked with a client for 3 months. The client decides that they're going to move on from counselling. They're feeling much better now, and they say, I'm leaving now, and I don't want you to have any of my data. Our relationship is finished. You had the data for the job that was intended. I want you to delete that data. What would happen, and what kind of a situation would you be in if a couple of months later that client laid a complaint? Maybe they went on into their life and then thought, you know what, that wasn't right, and lays a complaint against you. Your ethical body then calls upon you, and you don't have any data to back up your stance with that client. A darker scenario that may play out is if that person chooses to take their own life, and you may be contacted by the coroner, who has a legal right to ask you for the records and data that you have on this client. So first thing you would do, if you were deleting data, you would do it with guidance from something like the ICO, or look at who governs the data legislation in your country. You would then make sure that you note that down, so that if you are called upon, you can say what you did and why you did it, and that you were consulted. So defendable decision making. And of course, as you said, Rory, if you have your contract where you very clearly outline your data policy, that is going to stand you in good stead as well. So the client coming in understands and knows how you manage, keep, and store data that they may share with you. Make sure you know your legislation. Make sure you have your contract up to date, and consult with the ICO that you should be registered with anyway as a counsellor or psychotherapist if you are receiving any data or storing any data from a client. And that can be their name and email address in your inbox. That is still their data, and you are storing it.
Yes. And we've not talked about the insurance company, because obviously as a therapist, you will have insurance. And some insurance companies are very prescriptive in how long you should keep data for. And they may say 7 years after the client has finished with you, or in the case of young people, up to the age of 25, so 7 years after they turn 18. And some don't have a policy on that. So I think the ultimate answer is, if you're unsure, speak to your insurance company, professional body, or the Information Commissioner's Office, and take a view. And also try to get their advice in writing. Say, I spoke to someone on the phone and they said this and they said that. Doesn't really stack up legally. What you need is actual written responses that you can store. I would imagine, Ken, if we come into the real world, that it would be very unlikely that you would get a client who would contact you and say they wanted all their information. But the whole point of us discussing this is to hope for the best and prepare for the worst. We've discussed it today in the hope that we could raise awareness and signpost people into what they need to think about should they get a request to remove data.
Yes, it's a heavy topic, this, and it turns around every now and then, and no doubt it's going to turn again. And some parting thoughts on this. Part of the UK GDPR legislation says that we only keep the data as long as it is required from a client. So if we do see a client and they don't ask for the erasure of that data, After 6 years, do you have in your practice something that triggers off to remind you to remove the client's details? And how do you do that? How do you delete that data? Data compliance is now something that we have to take very seriously. It is a legislation, so we don't get to pick or choose whether we do it. We have to do it. It is the law. We've made a super duper handout for you on this tricky topic here. It's called Can Client Ask You to Delete Their Data? Understanding the Right to Erasure under UK GDPR. If you're somewhere else in the world, use this as a guide and look to your own data laws within your country. And if you're interested in the CPD library, where we have a lecture on this topic, counsellingtutor.com, click on products, and the CPD library for qualified therapists is there for you.